Good morning, everyone. Let me get situated here. I'm just seeing, there we go. There's Ms. Wentland. And Council, we are here again on the consolidated cases out of Cody, the zoning matter. I'll kind of outline how I would like to approach these today. There's one I think that might take a little bit more time. One of the things that I did want to ask is please, given the nature of this case, given that we want to make sure that there's a clear record, Ms. Kupke is on by Teams as well. So please, I would ask that you speak slowly and distinctly, identify yourselves when speaking. And there are a number of technical terms that might be used throughout this. And so that's part of the reason that I just want to make sure that Ms. Kupke can deal with these matters and keep an accurate record. That said, then it appears to me that we have three things we need to deal with today. There is the POCN's objection to the record on appeal, their motion to supplement the record again, and then their motion for stay. What I would like to do in going through what has been filed, it appears then, at least from the perspective of POCN and the church, that the church doesn't oppose the adding the June 26, 2023 Wentland and Wentland letter. The church doesn't oppose adding the June 15, 2023 transcript to the record. It appears to me then, Ms. Wentland, that the only thing that's left, at least as to the objection, would be some documents, attachments that you had to your motion that were actually part of an application that was withdrawn. Is that correct, Ms. Wentland?
Yes, Your Honor, that is accurate.
All right. Tell me why we would include those if the application was withdrawn.
Rule 1208 says that the record will contain, Rule 1207A says the records will contain the appropriate agency documents reflecting the agency action and its basis for its decision. And as we will argue more fully on the appeal, we believe there was an actionable, unlawful conflict of interest in this case. And those documents that were filed April 18, they're just two small documents. The Haskell, that's the architectural engineering firm that represented the church, their letter proposing a conditional use permit, and their April 18 letter proposing a special exemption. We submit that those need to be included in the record. They were provided to the planning and zoning members. They did consider it. In fact, one of our arguments that we believe will show the unlawful conflict of interest points specifically to those documents, and the planning and zoning members saying, hey, wait a minute. We want the hearing that is tied to these documents. It is true, it is accurate, Your Honor, that the Latter-day Saints Church did withdraw those documents and then resubmitted them with a May date, and they were exactly the same. That is true. But the fact that they were filed in April is part of the argument for conflict of interest, and so we would maintain that since they were considered by the planning and zoning, they should remain a portion of this record.
Mr. Hooks.
Good morning, Your Honor. The church's position is that those documents were not part of the record on the decisions that are being appealed. I'm not sure why those two documents were selected from the materials that were submitted with the first set of applications, but I don't know that it would be proper to just pick those two. And I'm not sure what arguments they're going to make with respect to those documents. I believe they're fairly innocuous, but our position is simply we should keep the record based on what was considered for the matters that are on appeal. And that would be with respect to the applications when they were resubmitted. And all of those documents are in the record. I would note that when the documents are resubmitted, those two Haskell letters are very similar to the ones they're trying to add. So again, I'm not sure the purpose of that, but our position is essentially let's stay with what the board considered on the matters that are on appeal.
Mr. Rumpke.
Thank you, Your Honor. As we said in our written submission, the city takes no position on either the motion to supplement nor the objections to the record. The board submits that the decisions in this matter were supported by substantial evidence in the record and are otherwise in accordance with the law.
Any reply, Ms. Wendland?
Thank you, Your Honor. Yes, and one thing I would add, the court left out one item, and it's an email dated May 22, 2023 from Mr. Matthew Burke to members of the church as well as the city. And that email is another tie to this whole issue of conflict of interest, which we'll raise on appeal. I can argue that issue at this point, but I suspect the court doesn't want to deal with that issue on this at this particular time. But the point remains, these were documents, this was an email that was considered, that was before the planning and zoning, and so it should not have been removed from the record. And it is part of the appeal in this case. We'd ask the court to allow those to be made part of the record. Thank you, Your Honor.
Anything else with regard to the email, Mr. Hooks?
Our position is the same. I believe that email is a request from the church representative asking to hold off so that we could respond to the concerns that the neighborhood group raised. So same position.
All right. Thank you. I'm going to take one more look at that. I will get you an email ruling directly after I have the opportunity to look at that again. Again, I'll try to be ever so prompt with the objection. Next, I would like to take the motion for stay, as I think I have a pretty good understanding of what's going on there. And then last, deal with the motion for additional evidence in the supplementation of the record. Deal with that last, as there seem to be a number of different things that I might have questions on. Do you have any problem, Ms. Wendland, proceeding with your motion for stay at this point?
No, Your Honor.
Please do so.
Thank you. May it please the court, counsel.
Ma'am.
For purposes of our court reporter, my name is Deb Wendland, and I am representing Preserve Our Cody Neighborhood, the petitioners in this action for discussion today before the court. I'd like to begin by laying some groundwork and give a little brief overview that I think will be helpful to the court throughout this argument. I would direct the court to the record on appeal at page 24. Or you can look at exhibit, you can look at exhibit 6 in my brief in support of the motion for stay. What I've just held up for the court is the architectural drawing submitted by the church with their application. Everybody agrees that drawing is in the record and that is the proposed build that is at issue in this case. Not to say anything about the court's eyesight, mine is bad, and so if it would be helpful, I would direct the court to record on appeal, page 572, where it's a larger printout of that document. Just to orient things, I'd like to work my way through that temple architectural drawing for the court, because the things that you will see in this orientation will come up over and over again, I suspect, both in my argument and opposing counsel's. The first thing I'd like to point out to the court is this temple draw shows a point off to the right-hand side where there's very, very tiny lettering, and it identifies it as the high roof. That high roof, I would submit to the court in the record, is essentially the roof for the lower portion of the temple build. Above high roof, then, you see the stacking drawing. Those are referred to by the architects for the church as towers, and they are towers 1 through 6. Those towers are 4-sided. They include a total of 8 large windows. They are supported by steel columns that run from the top of Tower 6 to the foundation of the building below. This drawing tops out at 100 feet 11 inches. Everybody's in agreement on that. The drawing is in the record. There can be no dispute about the labeling I have provided for the court, and it becomes important as we proceed. The purpose of the stay under Wyoming law, and we have lots more cases, and so you'll see me citing to the 10th Circuit because that seems to be where the action tends to be on stay. The purpose of the stay is to preserve the power of this court to make its ultimate determination on the appeal. I cite for the court the Comanche Nation case, which is a fascinating case, a 10th Circuit case, 2008. And the reason why I pay particular attention to that and ask the court to as well is because in Comanche Nation, the issue was real property. That's our issue today. And in Comanche Nation, the court said, when you're dealing with a stay specific to real property, that is different. In fact, it is a tougher reason not to grant the stay, because for issues of efficiency and finance and simply reclamation of the ground, real property commands a higher regard for why a stay should be granted. The purpose is to maintain the status quo before that ground is disturbed. That is what the petitioners have come to the court for today. We've asked the court to grant a stay pending determination on the, essentially what we would maintain is the unlawful building permit granted below. All parties in this case are in agreement that CBM Solutions, that's a Wyoming case, 2009, cites the standard for the elements of stay that are at issue in this case. And so I'm going to quickly run through them. Now, Your Honor, I would just place on the record and remind the court that in our brief, we have forecasted that we will be appealing the decision below based on many issues: lighting, glare, traffic, safety, view shed. All of those issues that are argued in the brief in support, all will be argued on appeal. However, because of time and efficiency, I will focus my argument today on the issue of height. Not to say that we're going to drop the others, but we'll focus on issue of height. Under the CBM case, the first element that must be proven for this court to grant a stay to petitioners is the court needs to make a determination, likelihood of success on the merits. In our brief, we have argued the plain language of the zoning ordinance dictates that the decision below be reversed and remanded. Let me direct the court, keeping in mind that drawing that you have, I'd like to direct the court to the basic zoning laws that are at issue in this case. First is 10-6-2. That's the Cody zoning ordinance that defines that when you have a building proposed for a rural residential neighborhood, that building can max out only up to 30 feet. It cannot exceed 30 feet. So let me remind the court, in this case, the facts are that the church was gifted land in a rural residential zone within the city limits of Cody. And according to 10-6-2 of the Cody zoning ordinance, nothing can be built in that rural residential zone that exceeds 30 feet. However, the city does recognize that there may be times for exceptions, and so the city provides an exception even for the height limitation, if necessary, in 10-14-2. That exception says if you feel that you have good grounds to step outside the height limitation, then you should apply for what's called a special exemption. You'll be hearing it referred to as an SE. The special exemption allows consideration to set aside the zoning height if the applicant meets all 7 requirements under the special exemption standards. I'm not going to go through those. We don't need to even talk about them. Everyone will agree that the church chose not to follow through with its special exemption application. This means the church chose to move forward on its proposed build right in the face of that 30-foot height limitation. How do you do that? How do you reconcile that temple draw with the 30-foot height limitation? Well, the first thing I would recommend you do, and the planning and zoning did this, they looked to the definitions in the zoning code. The first definition I'd ask the court to consider is found at Ordinance 10-2-1, and that's the definition for a building. In Cody, a building is defined as a structure having a roof supported by columns or walls for the shelter or enclosure of persons, animals, or property. Such term shall include a structure. As we look at the architectural drawing, this is a building. It has a roof. It is supported by columns. I've told you the columns for the tower go all the way to the foundation. It is supported by walls. It is a shelter and or enclosure. It's clearly a building. The definition then for building height becomes important because, again, 10-2-1 limits rural residential to 30 feet for building height. So, what is the definition of building height in Cody? A building height refers to the vertical distance between the average finished grade, you see that at the bottom of that architectural drawing, and either the highest point of the coping of a flat roof. I would submit to you that the city planner chose sub A as his definition of choice for this building because obviously the highest point of the flat roof is up there where you see that language high roof, and that's clearly under 30 feet. The city planner chose sub A. The city planner ignored sub B, and I'm in agreement with him on that. Sub B says the deck line of a mansard roof. This is not a mansard roof. But sub C is important for the court. The height is the height of a point midway between the eaves of the main roof and the highest ridgeline of a gable, hip, or gambrel style roof. It appears that the main roof would be that flat roof, and the highest point of the hip roof would be the top of Tower 6. For structures without a roof, buildings or structure height is the vertical distance from the average finished grade to the highest point of the structure, except those projections otherwise exempted or specified in this title. It's important to note, Your Honor, that Cody zoning law does not specially exempt anything in this title. So nothing can exceed that 30-foot height limit under 10.2.1 for building height. So why is there a problem? Why do we have a disconnect between a 100-foot and 11-inch building and a 30-foot building? The disconnect is the city planner wanted this building to succeed, but the LDS Church had chosen to withdraw their special exemption. And so now somebody had to come up with a definition that would shove a 100-foot tall building into a 30-foot restriction. And here's how we got there. I call it the red herrings from the city planner. First red herring is the city planner in his staff report, which I direct the court to at the record on appeal at 520. The city planner, just out of the chute, presumed that this building was a flat roof building. Why did he do that? If you look at the drawing, let me explain further. Where on the drawing, where you see Tower 1 connect to the bottom portion of the building, it looks like there's a connection. You can't see that. But in fact, between the roof of the lower building and the tower, there is space. The supports for the tower go all the way to the foundation, but the walls of the tower do not go all the way to the roof of the building below. There is an opening there. As a consequence of that, the city planner said, well, this is a flat roof. We don't have to count anything above the flat roof. But that's a red herring, because when you look at the definition of a building, nowhere does it eliminate something that doesn't have a roof or doesn't have a wall that extends all the way to the roof. In fact, the definition of building includes something that is supported only by columns and is not completely enclosed. That's red herring number 1. The second thing the city planner did to try and step outside of the definition of building height was, he said the steeple base has no roof. Now that took me a long time, and I'm still not sure about what that means, but I think what he's saying is the base of the steeple is open to the flat roof below. If you look at the record on appeal at page 525, the staff report works hard to make an argument that there is somehow significance to the fact of this opening. In fact, the definition presumes that it may not be enclosed. The definition of a building says shelter even. I mean, I can think of 99% of the loafing sheds in the state of Wyoming are supported by columns and not walls that go all the way to the ground, but they have roofs on them and they provide shelter and they're an enclosure, and no one would dispute in Cody zoning ordinances that those are buildings. Likewise with the temple. The third red herring is the staff report at Record on Appeal, page 526, focuses on main roof. And it appears that in the planner's estimation, the fact that the flat roof is the significant portion of the building somehow has significance in the definition of building, when in fact there is no reference to that in the definition of building. That's a red herring. Those things have interest and significance if you're talking about a building code. Well, that's a different story. But that's not what's at issue here. It's not the building code. The law in this case is the zoning code. The fourth and last red herring that I would draw to the court's attention is found at staff report record on appeal, page 552, or 7, excuse me. Now, remember, Your Honor, according to the drawing, the LDS Church calls these towers. But now we have a planner who's calling them a steeple. And in his analysis, he changes that into a rooftop projection. Because in his estimation, if we can identify that 77-foot build as something other than part of this building, if we can call it a rooftop projection, under the building code, his argument is, it doesn't count. And yet, there is nothing in the definition of building that has any indication that this 77 feet that is attached to this building down to its foundation should be anything but included in the definition of building. So we've talked about the definitions, we've talked about the red herrings. So what happened in this case? We had a planning commission that I would submit to the court worked exceedingly hard. I did not envy these volunteers, by the way, city residents who volunteered and were appointed to this unenviable task of listening to this and trying to make a decision. It ripped this community apart. So what happened? I would submit to the court that the record shows very clearly that the planners never did grant the definition from the city planner. The Planning and Zoning Commission never accepted the city planner's definition. The Planning and Zoning Commission did not come up with an alternate definition either. And they all lamented the fact that the LDS Church pulled their special exemption. If there was to be a way around the 30-foot limit, it was the special exemption. But that decision was made by the applicant. How do we know the strength of what I'm saying is true as to the planning and zoning? We need look no further than the record itself. If you look at the findings of fact for the conditional use permit that supports the unlawful building permit, by the way, you can find that at the record on appeal at page 804, the language that the planning and zoning came up with dictates this decision. If you look at page 813 on the record of appeal, the planning and zoning specifically found that the 30-foot height restriction does apply to this building. Case closed. That's been decided. The second thing the Planning and Zoning Commission found in their finding of facts was that the, quote, high roof of the building complies. Let's look at the drawing. The high roof of the building is that point demarcated on that architectural drawing as being about 20 feet. That's clearly under the 30 feet. It does comply. It also said, and the total height of the ancillary building complies. What's the ancillary building? We never talk about that because there wasn't a question. The ancillary building is an additional one-story low-slung building. I think it's used for maybe equipment, supplies. There wasn't a dispute about the height of the ancillary building. But it is interesting that the language that the planning and zoning used in their finding of fact is the total height of the ancillary building complies, and the roof height of, or the high point on the roof of the temple complies. I would submit to the court that that was the planning and zoning's way of applying the plain language of this case by saying, actually, it's only the lower portion of this building that complies. I'm sure there is a lot of doubt about that, and I'm sure opposing counsel will dispute that. But let me take the court very quickly through the transcript of the July 25 meeting. That's the hearing where the Planning and Zoning Commission landed on that finding of fact language. In that transcript, it is very clear. In fact, the planners take their turns putting on the record that they do not agree with that extended height of the building. Kim Bohr, you will find her disagreement and her decision not to support the height at page 18. Dan Sheen, you will find his disagreement and choice not to support the height of that building at page 28. Jason Wright, he says, it's not my job to fix the height for this church. I do not support the projection as presented at this site. You will find that at page 85. Scott Richards, page 72. The intention of the board was to approve the CUP, that's the conditional use permit, subject to them getting that special exemption. Page 87, he says, yes, I too am disappointed that the special exemption was taken off the table on this. From the beginning, I disagreed with the city planner's building height interpretation for the temple. The fact that the tower significantly alters the height profile of the temple. It elevates it to 101 feet. It does change the character of that neighborhood. It doesn't align with the master plan. Thereafter, the chair proposes language to try and fix the problem. And that's the language that limits approval of the height to the high roof note. And the chair then puts on the record at page 75, I consistently voted against the new interpretation code as to height proposed by the city staff. This is interesting. On page 79 of that transcript, the chair makes an interesting comment. If this height issue is gray, if there is a difference of opinion, if we should be following the building code and not the zoning code, if this area is gray, the burden is on the applicant. I see that structure as welded together from the floor. I just can't, again, square with the fact that if it is welded all together as one structure, somehow everything above a certain line doesn't count. This is the gentleman that wrote the language for the findings of fact that were later approved by that commission. Interestingly, even after the July 25th hearing, the planners are still maintaining height has not been approved above 30 feet. We know that because there was a meeting that followed on August 8. This is when the planners reviewed the site plan. On August 8, the planners were discussing, now wait a minute, we haven't approved height yet. We had that language in the finding of fact, but there was confusion because the site plan itself has drawings where there is the temple as proposed, as I've shown you on the architectural drawing. And so the planners themselves tried to negate that fact in their comments on the record. Dan Sheen, page 63 of the August 8 transcript. I will not be voting in favor of the site plan because of the height. Page 72, Mr. Sheen gives us a little more idea of the forcefulness of his commitment. It has been said that not approving the proposed steeple is discrimination. No previous building or applicant in the city of Cody has received an approval to construct something of similar height in a rural residential zone. Therefore, the applicant, in my opinion, is not being treated differently. Is denying construction of the steeple unduly burdensome? Allow me to quote from the Church of Jesus Christ Temple.org website. The Tucson, Arizona temple was originally designed with a 95-foot steeple, which would have required a special permit. However, Plans were altered and the steeple was replaced with a dome, reminiscent of the famous dome that crowned Italy's cathedral. That did comply with the Pima County planning, zoning, and regulations. Recent examples demonstrate that a temple can serve its intended purpose to the church without a steeple. And in my opinion, this board is not being unduly burdensome. The chair, the writer of the finding of fact that was approved, Carson Rowley, goes on to say at page 61 of that transcript, I make it very clear last meeting, I don't agree with that height interpretation. He tries to ameliorate the fact that the drawing in the site plan shows a temple at 100 feet 11 inches by saying, remember, the findings of fact language is still in the record. That's at page 73, lines 12 through 17 of that transcript. As to likelihood of success on appeal, Your Honor, petitioners would submit to the court that there is a very strong likelihood that petitioners, I feel presumptuous, Your Honor, but that's what the elements require me to argue ahead of decision making. But I believe the case is strong. The plain reading of the language and the facts of the record support the fact that on appeal, it is likely the court will need to reverse and remand the decision on that building permit. The second element that petitioners need to provide.
And let me, Ms. Wentland, let me ask. I mean, you've used up about 40 minutes, almost 40 minutes, and I've got kind of a limitation here on what I can do. How much more do you have on this part? Because I almost figured that the next part would take more time.
Your Honor, I apologize. I had no idea. If you can give me 5 minutes, I will wrap this up.
I'll do it.
Thank you, Your Honor. Apologies. Irreparable harm. I think the case makes itself. Again, look at the Comanche case. Look at the filings before the court. We have hundreds of pages of records where our folks submitted to the court irreparable harm, viewshed, violation of the law, traffic, danger, light, glare, all of those things, and I would direct the court to the record on appeal for that. And let me just add, the legislature, the state of Wyoming, and the city council found those items important enough to put them in statute and in zoning law, and those are the very items that we seek to protect today. So there is a irreparable harm. I point the court to the Polo Ranch case out of Cheyenne, 2003, where again the court accepts the idea that real property is dealt with differently. The threatened injury outweighs the harms, Your Honor. For 24 years, the very wonderful LDS community of Cody and the Basin have traveled 106 miles to Billings to go to a temple. Prior to that, for 55 years, the closest temple was Twin Falls, Idaho, and that was 385 miles away. Prior to that, the next 45 years, it was Salt Lake City, and that was 600 miles away. I would submit to the court, if you're balancing the equities here, which is what is required in the Burlow case coming out of the 10th Circuit, the balance of equities are in favor of petitioners. This will not unduly harm the LDS Church. And then finally, if the stay will be adverse to the public interest, absolutely not. Your Honor, what we're asking is for the court to enforce public health and safety as defined by the legislature and then the city of Cody. And so the public interest is what will be maintained by this stay, not harmed. I respectfully ask the court to grant the stay pending this appeal. And again, I apologize for the length of my earlier argument. Thank you, Your Honor.
Mr. Hoops.
Good morning. May it please the court?
Sir.
I am Kendall Hoops. I'm with Yonke and Toner, Sheridan, Wyoming. I represent the Church of Jesus Christ of Latter-day Saints in this matter. I appreciate the opportunity to address the court on the motion for a stay. The temple is proposed to be constructed on a lot that is approximately 4.69 acres. It's situated on the outskirts of the city of Cody. The land is zoned rural residential, and a couple of key facts that we'll be talking about today. The statutory framework and the ordinances allow for a place of worship to be built in a rural residential zone. This proposed temple is a single-story building. It has a flat roof. Ms. Wetland articulated the flat roof is approximately 25 feet. It then has an unoccupied spire, tower, steeple. Those words have been used synonymously, and I'll point the court to the language a little bit later on that they're used synonymously in the regulatory language as well. Because the tract is so large, the temple has been designed to be set back well away. It's approximately 470 feet from the center of the adjacent street. It's approximately 345 feet from the home, the closest home of a member of the neighborhood group. Those setbacks allow the church and were considered and are important in meeting the requirements of the conditional use permit, as we'll discuss. Quickly on the statutory framework, I'll direct the court to section 15-1-601. That's the statutes that allow cities to create a planning and zoning board, which is what the city of Cody did in this case. It authorizes those boards to make zoning decisions. And under that framework, the city has given the board in Cody broad authority to review these, to modify or to impose conditions or modifications on the conditional use permits or to deny them. And it's pursuant to that authority that they approve the conditional use permit here. A couple of comments about the legal standards for a motion for a stay. We're under 12.05 in the Rules of Appellate Procedure, which incorporates Rule 65 of the Rules of Civil Procedure. So many of the cases we cite in the brief and that we refer to pertain to preliminary injunctions. Our Supreme Court has often said a preliminary injunction is an extraordinary remedy, and I wanted to cite this holding. This has long been the holding, and it's the basis for the first prong. It says, will not be granted except upon a clear showing of probable success on the merits, lest the proper freedom of action of the defendant be circumscribed when no wrong has been committed. Most of the case law starts and stops with this prong, and we believe such will be the case with respect to this matter. The neighborhood group will not be able to show that it has a substantial likelihood of success on the merits. As the court knows, we've stated earlier, the church and the board are generally aligned now, given the status of the consolidated proceedings, given the status of the ultimate decisions made by the board. We're generally aligned in defending against the neighborhood group's appeals. There is a procedural and a jurisdictional issue that we preserved. I want to make sure I quickly address that because it's important. The conditional use permit, and actually I'll address this procedural issue before I get to the substance, but in the interest of time, I'll summarize this, and I'm happy to answer more specific questions. The conditional use permit was granted on June 15th. That was the night of that public hearing, a long hearing. Multiple people attended. The board took a motion and approved the CUP on that date. After that meeting, the church believed its permit had been approved. The neighborhood group continued to oppose, but they did not timely appeal any of the decisions made on June 15th. Later, at a subsequent board meeting, the board passed a motion to reconsider, to pull back the findings, and then tabled them. And that led to subsequent meetings and ultimately an amendment to the specific findings they had made on June 15th. Why is that important? It is from that amendment that POCN appeals, but they are trying to overturn the original decision made on June 15th. It's well established that the timely filing of a petition is jurisdictional and it's mandatory on behalf of the petitioner. Having failed to do so, there is not jurisdiction to overturn the decisions that happened on June 15th with respect to the appeal they're making to you, Your Honor. Even if the court were to find a problem later with the amendment, it wouldn't affect the original decisions made on June 15th. Now, they argue, oh, the June 15th decision was not final, and they rely on those subsequent board meetings where the board said we want to reconsider. We've cited the Wyoming case law. Interestingly, there are cases on this point. The Board of Adjustment doesn't have the power to reconsider or rehear a conditional use permit that has been granted unless the legislature has authorized it, which it has not done. And that precedent makes sense. Once a right is vested, once an applicant has its permit, it shouldn't be taken away without operation of law. In response, they also try to pick apart statements by board members suggesting that decision on the 15th was not final. I'm going to comment on that. Their argument of citing to individual statements a bit more when I talk about the substantive issues, but that's not a proper argument either. The board's review is of the formal motions taken. The record is clear that the conditional use permit and the specific findings were made by the board that night. Okay, I'll turn to the...
Excuse me, Mr. Hubbs. What you say they were made by the board that night? Clarify that for me. I just want to make sure that I'm tracking you.
That night, meaning June 15th. The record is clear with respect to their minutes from that meeting, and we have the transcript now that they approved the conditional use permit and the specific findings, which actually were read in to the record that night. They approved them on June 15th. Does that answer your question?
Yes.
Okay. Yeah, so I don't want to lose sight of that procedural issue throughout this process. It's important. But I do want to talk about the substance now because the substance is also important, and they're not going to be able to show a likelihood of success. They primarily turn to the building height issue. I want to address or approach this from a little more broad perspective, and then I will discuss the building height issue. So a discussion with respect to the substance begins with the standard of review. In a non-contested case proceeding, the court uses what they call the arbitrary and capricious standard. This test requires the reviewing court to review the record to determine whether the agency reasonably could have made its finding and order based upon all the evidence before it. The arbitrary and capricious standard is more lenient and deferential to the agency than the substantial evidence standard because it requires only that there be a rational basis for the agency's decision. That's important. In this case, we're going to be talking with respect to the substantive issues. Is there evidence in the record upon which the agency could have based their decision? Not whether a different opinion was asserted. There are many opinions asserted in this case. But under the standard review, we're looking for whether there is evidence to show that the agency had a rational basis for its decision. And I will purport to you, without going into the detail, there is substantial evidence supporting their decisions. They had detailed site plans. They had detailed photometry studies that showed the lighting of the proposed temple. even measuring to the foot candle with respect to whether there would be light spillage on adjacent properties. There was information concerning setbacks, distances, components of the temple spire that Ms. Wentland referenced. There was a geotech report. There was a comprehensive traffic report and a detailed stormwater water management plan. The church also had the board had considerable input from the community. At that meeting I referenced that happened on June 15th, there were hundreds in attendance. They actually had to move it to the Cody Auditorium to seat them all. Many spoke, both in favor of and in opposition to, including the neighborhood group members and their attorney. Anyone who wanted to speak was given the chance. They didn't turn anyone away. There was considerable amount of written input provided to the board. The court will see hundreds of pages in the record of comments, correspondence, information provided by the community. So without going more into that, there is substantial support for the board's decisions in the record. Their process was extensive. There was nothing arbitrary or capricious about it. So let me turn to building height. The opponents of the temple look at it from a very practical and basic standpoint. And to paraphrase the argument you heard, they essentially say, well, since the spire goes to over 100 feet, it's higher than 30, it must violate the ordinance. But their analysis doesn't look at the actual, well, they look at it, but they don't apply the actual language of the building height ordinance. And I want to point out a couple of matters. Ms. Wentland did fine articulating the ordinance. There are three components of that building height definition. And really the question the board was reviewing and discussing is which component. Do we apply subpart A, which measures to the top of a flat roof? Do we do B, which talks about a mansard roof, which this is not? Or do we talk about C, which talks about a gable roof? A gable is similar to an A-frame type of a building or a pointed roof. This is not a gable roof. It became apparent that this was a flat roof with a steeple. There was nothing unusual about it. This was a flat roof with a steeple. The church, I wanted to clarify some timing for the court's purposes in response to their argument. The church initially, when they approached the city, said, what do we need? And the city planner said, well, here's the process for a conditional use permit. Here's a process for a special exception regarding height. And so both of those applications were made. However, after the city officials, and primarily I'm going to talk about the building official here in a moment, whose job is to examine the code and to look at the studies. After they looked at this, they said, hey, we're under subsection A. We measure to the top of the flat roof. That building ordinance or definition of building height does not measure to the top of steeples, does not measure to the top of other rooftop structures. If it had intended to, it could have easily said so, but it doesn't. It applies to, it measures to the top of the flat roof. Once they said that, then the church said, okay, we'll withdraw our request for a special exemption. There was no subterfuge. The church was just trying to comply with the direction they were receiving from the city as we worked through this. The opposition did not refer something that's very, very important. Cody has also adopted by ordinance the IBC, the International Building Code. It has a section on building height, section 504.3, and it specifically accepts towers, spires, steeples. That's the phrase I told you. They use those words together often. And it accepts towers, spires, steeples, and other rooftop structures when calculating building height. So if there were any question in applying the ordinance that measures to the top of the flat roof, I don't believe there is any question, but if there were, when we turn to the IBC, it removes any question. The code accepts towers and spires, hence the reason that the buildings are constructed that way. That ordinance, that application is not unusual. Many jurisdictions have adopted the IBC. You'll see in the record other jurisdictions in Wyoming who have similar ordinances with respect to building height. The board also relied on testimony and evidence in their board meetings regarding other church places of worship in the city. They have not used the building height limitation of 30 feet to limit other steeples. There are multiple places of worship in the city of Cody that exceed 30 feet. So what the board decided here was not out of place with what it had done. A couple of other matters of clarification. Ms. Wetland quoted extensively from individual board members during different meetings. Some she quoted were in favor of the temple, and some she quoted were opposed to the temple. The problem with that argument is this court's review is with respect to the decisions they made, not individual statements during discussions. And there were multiple discussions on this issue. There were several meetings, several discussions, and one can go to those transcripts and pick out statements and guess at what they may have meant or what they were thinking at that time. But that's not what the court reviews. The court reviews what they voted on and what the formal decision entered was. And specifically on this issue, both on the June 15th findings, the board found that the building complied with the building height ordinance. And then on it, even in the amended findings, I'm reading on page 8 of those amended findings. It talks about principle 3.1.f of the master plan regarding building height. And the board found, and even those board members she quoted voted in favor of this, that the highest point on the high roof of the temple, as indicated on the plans, adheres to the 30-foot building height as set for rural residential zones. So it's clear in the record that the board approved this, the conditional use permit, and approved the building height of the temple as designed. Quickly, I will point to, I believe it's important for the court. Ms. Wetland talks a lot about the city planner did this and the city planner did that. Well, again, the court's reviewing what the board did. The city planner is not a decision maker. And more importantly, with respect to this building height, it was the building official, it's Mr. Sean Collier, who the board called to come in. And his information to the board is in volume 11, pages 8 to 16. That's a transcript of that board hearing that night. And he went through in detail with the board his review of the plans and designs with respect to building height. He went through the ordinances that Cody has, the building codes, things that dictate his duties as the building official. And he told them that the temple complied. They even pressed him on it. How confident are you? And he said, very confident. It was after his determinations and after his review that the church then said, okay, and they withdrew their special exception and proceeded with the conditional use permit that had been granted. Let me move to the other prongs quickly, Your Honor, and then we can move on. I know the court wants to get to those other issues. With respect to irreparable harm, case law says that the irreparable harm claimed by the movement has to be serious or substantial. It cannot be purely speculative. The harms they allege pertaining to view shed or lighting or traffic are primarily based on their own opinion, their own viewpoint of the situation. There are other neighbors in the area of the temple who have the opposite viewpoint. They believe the temple is a benefit to the community. Really, that argument just circles back to the merits. The issues of view shed, lighting, traffic were the issues that the board was deciding and balancing. They made very specific conditions in the approval of the site plan, changes they wanted the church to make. I think there's 15 specific changes and multiple subparts. They looked at these issues very closely. They took their job very seriously and determined this is what would be appropriate for the neighborhood, for the area. When the opponents argue irreparable harm to you, they're basically asking this court to disagree with the board with respect to those issues. Briefly, with respect to injury to the church, as Ms. Swetland outlined, yes, it is difficult on the members in the area. They have to travel quite a bit to get to a temple now. Further delay, continued delay is problematic to them. I've also outlined in the briefing the costs and expenses that this delay causes to the church. This is a significant project, significant time and resources committed to this. The last element is public interest, and that's probably a good place for me to conclude. This matter highlights why our local government and our laws pertaining to local government are important. This was a community issue. It was difficult on those board members. They balanced a lot of different viewpoints. It benefits the public to allow this to proceed once a Board of Adjustment has made its decision. Holding this up only furthers the difficulty they've been dealing with. Separately, protection of free exercise of religion is among the highest of public interests. Continued delay or continued stay harms that interest as well. I am happy to answer any specific questions the court may have. Our position is that the neighborhood group cannot show a likelihood of success on the merits. We request that the court deny their motion. Thank you.
Thank you. Mr. Rumpke, I saw your reply to this. Do you have anything you wish to add?
Thank you, Your Honor. Tom Rumpke with Williams, Porter, Day, and Neville on behalf of the Planning and Zoning Board for City of Cody. No, I do not. Thank you, Your Honor.
All right. Ms. Wendland, a brief reply, please, and then we'll get on to the your next motion. And you're on mute, Ms. Wendland.
Thank you, Your Honor. I apologize. I will be brief. And so I'm going to just hit very quickly. First of all, the setbacks is a red flag. It's a red herring. Mr. Hoops argues the setback solves the problem. The conditional use permit requires that you fit within the 30-foot height restriction. Doesn't matter how far you set back that building, it's still in a rural residential zone. That's a red herring. Number two, Mr. Hoops wants to say the final decision was made in June 15th. But he doesn't want that decision, Your Honor. He's appealed it. And the reason he doesn't want that decision is because if you look at the minutes, which Mr. Hoops admits is part of their record and evidence of the decision, it says it's specifically conditioned on grant of a special exemption. He can't want the decision coming out of the June 27th hearing either, because it specifically says the decision is for the conditional use permit is conditioned on getting a special exemption. It's not until the July 25th hearing that we actually had a final determination. Number three, the Planning and Zoning Commission were not given evidence as to the zoning ordinances on how to step outside of them. What happened was the city planner and the building inspector came armed with the building code. And it was fascinating, but it did not thwart the language of the zoning code. I can't emphasize enough. At issue is the zoning code and not the building code. Your Honor, with that, the last thing was the IBC. Mr. Hoops's reference to the IBC section 5043 that exempts towers from building height. Remember the definition of building height in the zoning code? It says, unless otherwise exempted in this title. Well, it is true, the city of Cody has adopted the IBC for part of its building code. The zoning code does not exempt projections in that title, and that's the law we're dealing with. Thank you, Your Honor. I would resubmit that grant of the stay.
All right, obviously this is a complicated issue, and given some of the argument here today, I'm not demanding that this be done, but I will invite, if you wish to submit any additional briefing on the matter of the stay or any further outlines that you wish the court to consider, I would ask that you do so not later than noon, January 26th. That will give you a few days to step back and look at this. But again, complicated matter involving a local government, political decisions, internal matters, and the court wants to give every opportunity to everyone to get the appropriate law before us. The next matter then is supplementation of the record on the conflict of interest matters. Given our time right now, Ms. Wendland, and given where we are, I'm going to have to limit everyone to about 10 minutes. So, Ms. Wendland, your motion.
Your Honor, I will be very brief. I have the unique issue for which we are seeking to supplement the record is the conflict of interest. That is an argument we are allowed to make on appeal. In fact, it has to come there. It can't be decided here. Nothing that opposing counsel can argue here today in this hearing will take away our ability to make the conflict of interest argument on appeal. But we want to supplement that record because we need that additional evidence to fully make the argument that is by law allowed to us to make. The purpose of the supplement specifically under 12.08 is to allow additional material, new evidence that the court can consider actionable, unlawful conflict of interest. This is exactly in keeping with what 12.08 would allow. Why didn't we get the information sooner? Your Honor, that is not the fault of petitioner. We requested this information in a Wyoming public records request back in May, but a lot was going on. I'm not faulting Mr. Colpicti. He had a lot on his plate. But the fact is, we did not get the internal communications, which are a matter of public record, until in September, middle September. By that time, we had to have already filed our appeal. So the fact that that evidence is not in the record does not negate the fact that that is still a valid appellate argument and one that needs to come in. And I would submit to the court, it is completely semantics to call this new information new evidence. It's new only to us. It is emails between the church and the city and the planning commission or the planning and zoning board. It's not new to anybody except us, but it does go directly to the valid argument of unlawful, actionable conflict of interest. And if the petitioners are not allowed to raise that argument, I think that would be a tragedy, Your Honor. I think that itself would be a reason for appeal. because the unlawful conflict of interest was there, and these public records prove that. And so for that reason, Your Honor, it's well within the case law that I cited in my brief and 12.08 that evidence comes in on the appeal. Thank you, Your Honor.
So you're asking, just to be clear, you're asking only for the admission of the records and not a separate evidentiary hearing. Is that correct?
That is correct, Your Honor.
Help me then, because I have, on step number 2, help me. I have read and reread your submissions. I've looked at the governing law. What is it? And I saw one email in there, but I thought I'd better ask the question. What value is it that the planner received?
So, Your Honor, I don't have that brief in front of me, but the law in Wyoming, and remember, let me just back up really quickly. Remember, the issue of conflict came up immediately, even before Preserve Our Cody neighborhood was involved. It came up through city officials.
Oh, yes, I'm well aware of that, and I'll get to that. I'm well aware of the timing. That's an additional complicating factor. The fact it looks to me internally and politically, that issue was raised before any vote of the voting members were taken. Aside from that, then, my question is, help me. I looked at this. I saw an email in there that could have been a job offer. What value under 15.9.220 did the planner receive?
It's 15.128. The value he can receive is direct or indirect, monetary or not monetary. And in his case, it was standing within that church, standing within that LDS community. Certainly the job offer, that is a powerful thing within that organization. And that fact is noted in several of the emails, not just the job offer. However, that certainly is in there, but also
did he take that job?
Community.
Do you know? Can you help us? Did he take that job?
The offer, Your Honor, was if this doesn't work out, then and you need a job, I'll have one for you. He's still employed. So far, it's worked out. I'm on the defensive. So far, it's working out for him because the Preserve Our Cody neighborhood is on the appeal side of this. So in the event, ultimately, the temple does not get built, we'll see if a job materializes for him. But remember, under 128 of the statute, for an employee such as the city planner, it's a direct or indirect benefit, and it need not be monetary.
All right. Anything else, Ms. Wentland, that you want me to know on this issue?
I just would clarify, Your Honor, that it's the documents that we've actually submitted to the court and no others.
Right.
So there's no need for an evidentiary hearing. And
I very much appreciate that clarification because it was not clear to me in your submission that that's what we were talking about. Mr. Hoops.
Thank you, Your Honor. So initially when I saw their motion, my reaction was, I believe the court's already decided this issue. Their brief was, and the documents they submitted were the very same that they had submitted back in October. So you saw my response. I just incorporated our response, and so that the record would be clear, that was our position. Let me respond to their comments and their argument today. Ms. Wetland distinguishes between the concept that she can make this argument on appeal, which I don't disagree with. I mean, they can make any argument they want to make on appeal, but the question for the court is whether they can add these documents to the record. And that requires a determination of materiality. It requires a determination as to whether the documents were available for the board and whether there's any evidence of misconduct. And I would just briefly address those issues. This issue of bias or conflict was not new. It was raised at the very beginning. The city planner was forthright. He let everyone know he was a member of the church. The city attorney addressed this at the very beginning of that June 15th meeting and clarified that religion alone doesn't create a conflict. I think the court's question about, well, is there any specific benefit that he received is the right question. And the answer is there's not. These documents that they submit are by and large documents you would see a city planner. City planners correspond with applicants and correspond with the board. There's not evidence of misconduct or intentional misappropriation of his duties. The court did mention there's an email from someone in the community. I think the court was referencing to that suggestion that, hey, if things don't work out for you, come work for me, or something to that effect.
And actually, Mr. Hoops, I think it was, if memory serves me in reviewing the documents, I actually believe the email came from the donor of the land. Is that correct?
He's in the family, yeah, the neighbor Mr. Nielsen, yeah, in the family. But I think it's important the court knows there's a couple points about that. He doesn't speak for the church, nor does he speak for the city planner. And whether he meant that letter as just an offer of support to a city planner who was being bombarded or had some other intent, we don't know. The focus is, did the city planner ask for a benefit or receive a benefit? And he didn't. The statute that we look at, there's a couple of statutes that apply to this. The court referenced the one in Title 15. We also have what's called the Government Ethics and Disclosures Act that defines what is a interest for that would create a conflict. And that law talks about something that is substantial and direct. And it also says the public official has to receive a benefit that is greater than or a detriment that is different than the community at large. The city planner doesn't have any benefit any different than any other member of the church in that area from this temple or detriment. And frankly, there's other members of the temple will benefit the community. There's evidence about the benefit to the properties, commercial benefits. It's not just members who will benefit. So saying that the temple being built has a specific or direct benefit to the city planner isn't accurate. And then the last thing I would point out is this suggestion by the opponents that the city planner somehow dictated this process is just not correct. He's not a decision maker. It was his job to work with the applicant and make recommendations, but he did not vote. They accepted his findings sometimes, and the board rejected his findings sometimes. So the suggestion that he made this happen is just not supported by the record or accurate. So I incorporate the briefing and the legal arguments that we've asserted before, primarily the Johnson case and the Gerard case that have kind of gone through this Rule 12.08 analysis and how it changes, how it dovetails with the standard of review and the importance it is for the court to make sure that it doesn't supplement its opinion. These issues she's talking about aren't material to any issues that are on appeal, and they were known by everybody and addressed by the board. Thank you, Your Honor.
Mr. Rumpke.
I have nothing to add, Your Honor. Thank you.
All right, very good. Ms. Wentland, anything else?
Very short, Your Honor. The issue was addressed, but the city planner used the wrong statute. He used 127. The appropriate is 128. The issue wasn't addressed, but it was a concern, and it remained a concern with city officials, including the mayor and the city council throughout this process. Why is this so important? It goes right to the last item that Mr. Hoops referenced, and that is, what did Mr. Stoll, the city planner, get? He orchestrated this. He orchestrated the June 15 meeting. He orchestrated and the final result there, and the June 27 one. The best evidence of that is the hearing that Mr. Hoops wants to rely on as being final. In the June 15 hearing, the minutes reflect that they did not approve that CUP unless it also got a special exemption. And yet, the city planner tried to capitalize on the fact that they approved his findings of fact with that verbal exemption and tried to act like it didn't happen. And then we come to the June 27th meeting and he makes the same kind of argument. Your Honor, there is a conflict of interest when a leader in that church orchestrated delay and misreading of the codes by focusing people on the building code instead of the zoning code, by submitting findings of fact that did not comport with the record. Those are conflicts of interest, and they don't have to be direct. An indirect one under 128 is sufficient to overturn this decision below. We would ask the court to allow the supplementation of this evidence for the appellate hearing. Thank you, Your Honor.
And given what was raised, Mr. Hoops, the court feels that it has to give you an opportunity to briefly respond to that.
So, Your Honor, to do it briefly, I'll say it this way. I disagree with her recitation of what happened on June 15th. The record's clear that the CUP was granted and that the findings were adopted. There's not a condition on a special exception, and the statements that she's made otherwise are not accurate. I would direct the court to our brief. If you had time and if you want me to, I'm happy to pull out those board minutes and take you specifically to them. But I think for this part, I think it's appropriate that I just say that's not accurate. On June 15th, the board did approve the CUP and the findings, and there was no condition on a special exception. Pointing to comments during the discussion or isolated comments from a board member in opposition don't change that fact. And so, and I guess to her point on adding to the record, the city planner made recommendations. It's the board who makes the decisions, and their written findings are what are on review. And they did not always adopt what he recommended. And the statements to the contrary that he dictated or orchestrated it are not accurate. Thank you.
And one more time, Mr. Rumpke, did that cause anything that you wish to add?
No, thank you, Your Honor.
All right. All right. Here's what I'm going to do with this then, ladies and gentlemen. I wasn't certain this would be necessary. It might not be, but still, I'm going to do the same thing with this. If you wish to present any additional matters for the court consideration after hearing the arguments today, I'm going to give you until noon on January 26th. That's a Friday. To get those to us, filed with the court, emailed to me. Obviously, I don't have the file handy, and I will consider it at that time. I will get you the other ruling, the objection on the record, hopefully prior to that. Obviously, this is one of those cases that was assigned to me immediately after June 15. It is these four cases now are substantially different than the case that I took under assignment, and trying to keep up with this has been, shall we just say, a challenge. The other challenge, counsel, as you're well aware, that the court has to confront here is gleaning specific issues of law and separating those from the discretionary matters that are made in a political forum by those who have been taken into elective office or appointive office to make those types of decisions. And so one of the challenges that the court faces here is I'm not allowed to substitute my judgment, whatever that might be. Ms. Wendland has pointed that out, that whatever happens, if there's a change, it needs to be remanded. But sometimes gleaning those and parsing those out to very simply the narrow issues that the court may consider is a bit more of a challenge in something like this. So with that then, counsel, I very much appreciate your comments today. I appreciate your courtesies. And one more time, I'm not requiring you to make any additional submissions by the 26th at noon. I'm giving you that opportunity. Ms. Wentland, any questions?
No, Your Honor.
Mr. Hoops?
No, Your Honor. Thank you.
Mr. Rumpke?
No, Your Honor. Thank you for having us this hearing.
Counsel, thank you for your courtesies today.